recording. So there you go. So now I'm going to go back to my screen and all right. So we've been through Rule 99. I want to go back on the recording and touch on the method of service. The amendments to Rule 106 that state that substituted service can be made by social media, email, or other technology, and reiterate the caution that in determining whether to permit electronic service of process, the court was going to consider whether the technology actually belongs to the defendant or whether the defendant regularly uses that technology. So, all right, now we go back to moving forward to Rule 108, service of process in foreign countries. This is just, there was an amendment to that rule which changes the way you might serve process in foreign country. Just wanted to make sure that we are all aware of that. Expedited actions, we talked about this earlier when we talked about the limits being raised from $100,000 to $250,000 for jurisdiction, for permission of expedited actions, and for permission of the lower level 1 discovery. So, and again, it also, under the expedited actions rules, if you're going to claim that your claim is under $250,000, you do not include interest, statutory punitive damages, and the like in that claim. But if you're claiming over $250,000, you may include those items in your claim. Okay, and again, this is what we've done. The difference between level 1 and level 2, we're just changing it to change that jurisdictional limit to $250,000. And we're going to talk more about family code cases later because there are some differences and exceptions in the family code, which are going to be quite interesting to us family practitioners. Okay, so now we're getting into the meat and potatoes here, the rules of discovery, permissible discovery and written discovery. Now, we are now required under the new Rule 194, required disclosures are a form of discovery, and the word required obviously describes what they are. And this removes requests for disclosure. So there are no more requests for disclosure going to go out from our offices. We are going to have to disclose. So stepping back on how does this affect us as practitioners, we're going to have to revise our intake and our initial consultation with these clients to make sure that we get all the things that are required to be disclosed in order to comply with that rule. The consequence of not complying with the required disclosure rule is that you are not going to be able to use items at your trial if you have not disclosed them under Rule 194 within the correct amount of time. Now, another thing to consider in real life as practitioners is there are rules. There's an exception if the parties agree by a Rule 11 agreement, or if the court allows, then you can expand the time that the first disclosures are due. So, good idea to keep in mind that Rule 11 agreement and make sure that if you need more time, that you get with opposing counsel and agree to extend that time for those required disclosures. You'll see there the things that you're required to disclose can be pretty lengthy and pretty time consuming to get. Okay, so the game changer. Initial disclosures must be made at or within 30 days from the filing of the first answer or general appearance. Parties first served or joined after the filing of the answer or general appearance must file their initial disclosures within 30 days after the service or joinder. So anytime, when you start the case, the clock does not start running. It's after the first answer, appearance, or joinder is made. That's when your clock starts running, 30 days that you have to disclose the many things that you have to disclose. And the court or the parties by agreement can extend or modify the deadline. Okay, initial disclosures do mirror the former requests for disclosure, but there's an additional requirement. Now, the rule requires that we disclose copies or a description of all documents, electronically stored information, and tangible things that the party has in his possession and may use to support his claims or defenses. So this is production of documents in your required disclosures, basically. So be advised that it's going to take some time to get this together, and make sure that your client expectations are managed accordingly to make sure that you get all the documentation from them that you need to comply with this rule. Okay, so things that family law practitioners need to know. There are very specific things now that are required to be disclosed at following the initial answer of a respondent in a divorce or annulment case. The parties must provide the opposing side with copies of the following: for the past 2 years or the length of the marriage, whichever is less. The deeds, the liens, lease information on all real property, all documents pertaining to employee benefit plans, all documents pertaining to life, casualty, liability, and health insurance, and all account statements of any financial accounts. So 2 years back. So on your initial consultation with your client, it would be well advised that you go ahead and tell them, I'm going to need all this stuff right now. We're going to need to disclose all of this before we are even asked for it. Similarly, in suits regarding child or spousal support, the parties must provide copies of policy statements, summary description of benefits for medical and health insurance, anything that would be available to the child or the spouse, the last 2 years of tax returns, 1099s, W-2s, Schedule K, and the parties' 2 most recent pay stubs. None of this is shocking for family practitioners, but the idea is that it is so pushed up now and so required initially that it's important that we recognize that this is going to change the way we encounter and deal with our clients in the initial stages of a divorce or custody case. All right, there are new rules regarding testifying expert witnesses. If you are going to have an expert testify at your trial, ultimately, you have a duty to disclose a whole lot of information about your expert within your initial disclosures or within the same 30-day period. And it's also including the curriculum vitae of your expert, papers that they've written. I refer you to Rule 195 for the very specific items, not just their name and address, but their subject matter and their, they want their resume, all the publications that they've authored in the previous 10 years, except that when an expert is the responding party's attorney and is testifying to attorney's fees, then a list of all other cases in which that expert has testified. So when you're the expert testifying about your attorney's fees, you are somewhat unburdened by this, but and a statement of the compensation to be paid for the expert's study and testimony. So all of those things have to be disclosed. And so like I said, this is some game-changing amendments to the discovery rules that are really going to affect the way we deal with our clients and practice our cases going forward. And in reading the commentary to the amendments, it's clear that the Supreme Court wanted to speed up the process, wanted to make expedited actions a little bit more accessible to people, and want to make the whole discovery process a little more sped up to get things rolling much faster. So I think the intent behind this is probably expeditious as far as the court system and the litigation system are concerned, but it's also going to put a lot more work on us attorneys. So thinking through the practical matters, like I said, make sure you get some Rule 11 agreement language together, make sure you get some good intake information and create those expectations in your client that before we ever get started in this case, we're going to have all this information readily available to disclose to the other parties, and just be ready to perhaps reconsider your initial retainer amount in light of all the additional work that has to be done in the very beginning of your case. So things to think about. Okay. Yeah, so again, in Rule 195, here's some of the language of it. Parties must disclose the name and contact information of the witnesses they're expected to offer at trial. And there are certain classes of cases that are exempted from this, and that is in Rule 194.2D, proceedings exempt from initial disclosure. The proceedings that you don't have to make these initial disclosures are review of an administrative record, forfeiture action arising from a state statute, habeas corpus. If your family case is filed by or against the 4D agency, you're exempt. If it's a child protection action or a protective order action under the family code, you are exempt from these initial disclosure requirements, and other actions involving domestic violence and an action on appeal from a justice court. So those are your exceptions where you don't have to engage in this very rigorous disclosure process. All right, so now discovery information in a nutshell. Screenshot this screen, because this is a summary of everything that we've been through. And this is where I really am obliged to the Corpus Christi young lawyers to get this, this information summarized this way. Initial disclosures must be made at or within 30 days from the filing of the first answer or general appearance in the suit. Okay, parties first served or joined after the filing of the first answer must make their initial disclosures within 30 days. Okay, again, I'm going to keep referring you back to think Rule 11 agreement to expand your time for this. The initial disclosures closely mirror the former requests for disclosure, so there's no great surprise as to the contents of these things, but we are also going to include all these documents in our disclosures up front before the need arises for the other party to ask us for them. So and think about the special updates for the divorce cases and the child custody cases, the family cases, those tax returns, those pay stubs, all of that. Don't wait to be asked for them. Just get them ready to disclose to the other party very, very early on in the case. All right, well, let's see. All right. Okay, so I have a question in the chat. If a case involves domestic violence, do you still do the initial disclosures? Yeah, that is good. The language of the statute, I actually read it out of the statute, and it is a little bit confusing. So it says that following proceedings are exempt from initial disclosure, but a court may order the parties to make particular disclosures and set the time for disclosure. And the one actually says other actions involving domestic violence. So that is kind of, yeah, that's kind of obtuse there. What do they mean by if it involves domestic violence? If it's a normal divorce case but there was domestic violence, are we excused from the initial disclosures? I doubt it, but it may be that you will have some leeway from the court to expand, you know, to be able to get some hearings done to protect your clients and the parties before the disclosures have to be made. So that's my opinion. I will be happy to entertain other people's opinions on that. Has anybody gotten involved in this in a domestic violence case? If you want to answer, if you have, just please unmute yourself and go ahead and talk. I mean, this is a good experience for us to hear each other's experiences. So, all right, no thoughts on that. All right. Okay, the expert disclosure rules are something that we need to study and become aware of, and know that if we're going to use an expert, let's ask them early on if they've updated their resume, if they have a list of their past 10 years worth of publications, things that they've published. Make sure that we vet our experts very well before we sign them up to use them. All right, so All right, now here we go. We haven't been on here for an hour yet, and I anticipate that I want to have some discussion among all of you professionals out there, because I don't even purport to know more than anybody else. I just gathered up this information and wanted to lay it out there for us to open up for discussion. But when you're ready to file for your credit for this course, it is a 1 hour regular credit. There is no ethics on this particular course. There's your course number, and there's a QR code there. You can snap a picture with your phone, and it'll take you right to the page where you can apply for your credit for this course. And if anybody needs me to come back to this page, I will. But in the meantime, I am going to open things up for discussion, questions, experiences. What have you encountered, if any, with these new rules? And I didn't plant any plants in the audience, so if you have something to share, I really wanted to save some time here to share. And I see Betsy Grubbs is on the call. Betsy, do you have, I think you and I have talked about this. Do you have any experiences?
We do. What I'm finding is just like the status conference notices that are in Galveston County that are buried in the citations, people are just flat out ignoring these notices of initial disclosures. Now, there's been some discussion via the Facebook groups about what's the remedy, what should you do? And I think you've hit on it very briefly about 197. If somebody doesn't answer their disclosures, don't open your mouth, because the automatic exclusion rule prevents them from being able to put on any evidence at trial. And the only person that can testify is the named party. So if you have a company, if you have, and it just depends on how hostile you are. This is something that people are just ignoring because they don't know what it means, especially, and I've seen it come across in the probate, within the probate lawyers. And I think Margie, you and I talked about this, is nobody, if you are not that familiar with litigation and the rules of procedure because you don't use them in your everyday practice, i.e. for standard run-of-the-mill probate, you're not familiar with the fact that these things even existed. And now all of a sudden they're a mandatory requirement. Now, I did have a question for you about the service under 106. So remember, we talked about the modified Rule 106, and after you get an order from the court, and I presume this is just like a standard motion for substitute service, right, where you have demonstrated that that person does actively use Facebook, so it's should give them notice, just like the standards for a traditional 106, which is a motion for substitute service. You have to demonstrate that A, they live there, B, somebody's confirmed they live there, there's vehicles there, it appears that there's activity in the house. So my question for you under 106, where you're adding this social media service, is that something that the lawyer will do, or is this again something that you will, as far as the actual service, or is this something that you will then get a process server with a presence on Facebook to serve them by social media? That was something that came up because, I know of very limited circumstances where the lawyers can actually serve the initial process, and it has to do with service on Secretary of State. Mm-hmm. But do you have any feedback or comments or, any idea? So this would still be a process server that has a Facebook presence or Instagram or something like that, serving them. But my concern with that is, if I'm not friends with somebody, their messages to me go in junk.
Right. I know. I agree. That's going to be interesting to see how that plays out. I don't have any experiences with that. If anybody on this call has experiences with that, raise your hand or speak up. This is why we're here, to share. This is all new territory for all of us. The only information that I have on this is that the court will, use that will consider whether the person actively uses that space. But yeah, who sends the Facebook message? If they're not friends with them, they're not going to find it. Does it have to be a process server? Can you ask the court to order that the wife can serve the husband by Facebook? I mean, I don't know what that's going to end up being, because I don't see anything in the rule that says it has to be by any particular person. You know how the process service, it still can just be someone over the age of 18 posting it on the Facebook timeline to check their messages. That's an idea. Yeah, I don't know. I think a lot of this is going to take time to play out.
I think that was a valid suggestion, because I mean, I would be hesitant to just slap this on their Facebook timeline and say, looky here. But I do like the idea of check your messages. But
right.
You know, if it's coming from a process server, especially somebody that has like ABC process in their name, everybody's going to know what it is anyway.
Right, they're gonna, yeah, so. I know, and then if the person, I mean, I guess it's like the posting it on the door. You don't have to prove that the person actually read it, but I don't know. I mean, you know, if you get an order that they can post it on the door, you don't have to prove that the person actually picked up the paper off the door and read it. So I don't know what they're going to do with Facebook. Interesting. I think it's going to be fun, in quotes, to see how this plays out. Anybody else have experience with that 106? I think I had heard somebody in our probate group had some kind of experience with a Facebook service, but I don't recall who it was or who it was that made the service. So great question, Betsy. Anybody else have any other questions about any of these discovery requirements, any experiences? I love Betsy's comment and I just want to reiterate it because it was so important. If you are aware of the required disclosure rule and opposing counsel isn't, and they don't send you the required disclosures, one option for you would be just don't say anything. Don't file a motion to compel. Just go on to trial, and they're not going to be able to put on any of their evidence. That's sort of a mean way to do it, but it's very interesting. Okay.
I have a question.
Okay, go ahead.
Go ahead, Bill.
I have a couple of cases where they were filed before these rules went into effect. I'm interested in the retroactive application or lack of that application to these rules regarding discovery. Like I've got at least one case I know of where they never did answer their request for disclosures, and I'm about to send them some discovery request, and I'm wondering, do I have to give them my disclosures before I can send them discovery request, or not?
Okay, great question. Yeah, under the new rules, yes, you do. You cannot send out requests until you have given over your required disclosures. But this, I am really 99.9% sure on this. If your case was initially filed prior to January 1st, 2021, you're still under the old requests and the old rules. There are no required disclosures. You have to request the disclosures. But it's for all cases filed on or after January 1st. When case filing date, not answer filing date, case filing date, January 1st, 2021, now these rules apply to these cases. So it goes by the date the initial pleading was filed as to whether you're under these rules or not. But once you've established that you're under these rules, then yeah, you have that 30 days from the date the first answer or response is filed.
Okay, thank you.
Yeah, you're welcome. All right, so I'm back on David Schleicher. David, you're allowed to unmute and talk if you want, but maybe you could explain what you mean by suspect if posted filing of the suit to their Facebook page, you would know they got it when they deleted the post. Okay, well, I guess, yeah, that's true. But I wonder if we even have to prove that they got it if we get the order saying we can serve that way. So, Okay, okay, Kenny Sumner's on this call, and I'm gonna call him out here. Kenny, have you had any litigation, probate litigation experiences with these new discovery rules? Oh, he didn't know I was gonna call on him. All right, anybody, any probate practitioners have any experience with these new rules? Philip? No?
No.
No? Okay, thank you. Well, thank you. I know we're all in this together. We're gonna see how this all plays out.
Yeah.
Margie, I wanted to go back and cover the question that was just asked about, can you send additional discovery if if they haven't responded to their discovery or the initial disclosures, met the initial disclosure. It says under 192.2, unless otherwise agreed by the parties or ordered by the court, a party cannot serve discovery on another party until after the other party's initial disclosures are due. It doesn't say after they've done them. So this is the whole thing, you know, for a long time, initial petitions or original petitions had requests for disclosures buried in them. You know, I've done a lot of defense work defending against debt buyers and debt collectors, and that's one of their tricks. It's burying requests for admissions and all of that stuff in the petition, and then doing the gotcha with deemed admissions. That's no longer allowed, and you can't send requests for disclosure with the initial petition anymore either. So it doesn't say when they're completed, it just says when they're due.
When they're due.
And the other thing that it is my humble opinion, you know, there was a question as to whether or not you have to notify somebody when they haven't responded to their disclosures. The question is whether or not, you know, yeah, in the school of fair play, the question is, if your client gets an advantage by them not responding, the other side not responding, the question is that malpractice for you to reach out to the other side and say, hey, by the way, you didn't do this, because it could hurt your client. So,
that's a great point, because under the old rules, you have to do a motion to compel to
not on disclosures, not if they fail to answer anything. I mean, if they fail to answer, you still don't have to do a motion to compel. I mean, there never was. So, you know, I'm still of the old school. You have no obligation, and perhaps it's against your client's best interest if you do reach out to the other side about a complete lack of response.
Yeah.
So,
well, good point. Yeah. So I don't know, but in a family case where one party, let's just say the wife, really needs the husband to disclose the bank account statements and his pay stubs and his tax returns, because sometimes the wife doesn't have access to all that information. And if they don't send it out in the required disclosures, now you got a problem trying to prove spousal support or child support. So in those kind of cases, I think there are going to be situations where you're going to have to reach out and ask or get a motion to compel.
Well, in that situation, yes, or just simply send request for production
right
after the time has run. But there again, I don't play in family law, so that's not my lane. So.
Yeah, and it's a different world, and that's why the Supreme Court carved out these exceptions, these specifications for family law cases. It's a different world. Sometimes you have to be more on the play fair court than on the okay, thinking out loud. The new rules create some issues in cases where an attorney ad litem files an answer. Oh, that's food for thought. Yeah. So what does the attorney ad litem? What is their responsibility going to be? What are their disclosures going to be? Interesting.
I would say look at the initial citation to see whether or not the unknown errors were triggered. You know, whether there's a duty to comply that's triggered by the citation. There probably is. I mean, I just haven't seen one yet.
Right. Yeah. I think that's a really, really good question. And then attorney ad litem is going to have to reconsider their fees if they're going to have to be. But again, in the School of Fair Play, you could do a Rule 11 with your ad litem, a Rule 11 agreement saying that you can modify their required disclosures or their time for disclosing and work it out with them. But yeah, good question. So what other food for thought do we have? Okay, what other envisioning do we have with these new rules of what could go wrong? All right, thoughts on, does anybody have any thoughts or need to talk about any of the foreign service of process? Any questions on that? Service of process in foreign countries? The only change to that rule is that it clarifies that the service cannot be prohibited by an international agreement. I don't think that surprises anybody, so that's kind of a boring change, but that's what that one says. The new limits on discovery level 1, discovery level 2, expedited actions. I have honestly never done an expedited action. Has anybody here done one and has any stories to tell about that? Okay, we have a question that popped up. Did Betsy say not to send requests for disclosure if serving discovery after the opposing party failed to produce initial disclosure? I think the conversation there was, and Betsy, you can correct me if I'm wrong, but I think the conversation was if the required disclosures are required because of the timing of the lawsuit, and the opposing party fails to send you those required disclosures, now you have a choice. You have a choice. Do you reach out to them for the disclosures? Do you send them requests for production? You're not going to send requests for disclosures because those are like it's not a thing anymore. Requests for disclosure is not a thing. It's required disclosures, and then you've got requests for production, and you've got interrogatories, which are permissive to send out. But yeah, the question is, if you do that and you keep prompting the opposing side to give you information, then they're going to be able to use it at trial. So is there a situation where you would do your client a better service by keeping your mouth shut and showing up at trial and all their exhibits and all their evidence is excluded because they didn't comply with the required disclosures? So I think that was the conversation. That's just a choice I think you're going to have to make on a case-by-case basis if that comes up. Okay, can the defendant file his mandatory required disclosures late without being prompted? Just file late. Yes, he can file late, but you can still say, well, he filed late. He served him late. He can't use any of that at trial. So yes, they can, but then they can't use it at trial. That is the consequence for filing that late. Now, can they ask for extended time and get a court order or a Rule 11 agreement to extend the time to file it late? Yes, and yes, and yes, then they can use that information at trial.
31 days later, you don't file your RCA, you can't use them in court.
I hear somebody talking, but I can't really hear you. Okay, all right. So yeah, so I think we have a lot of food for thought about what we're going to do with our requests for production and our interrogatories going forward. If we don't get those required disclosures, is like game over and yeah, we win, you didn't disclose anything? Or is it, no, we need this information, so now I've got to go back and send requests for production? Because you just can't send requests for disclosure anymore. It's just not a thing. They don't have to answer a request for disclosure. But they do have to send you all that list of stuff. So take a good look at Rule 194 and all of the types of disclosures that have to be made, and make sure you get that information early from your clients. That's just, yeah, because you do not want to be the one to miss that 30-day deadline and to not give everything that's required and then take that chance on not being able to use it at trial. So we really should have applied for ethics for this. I think we've had more ethical conversations here than simply informational ones, but you know, we still get a credit for this. All right.
Margie,
yeah.
Margie, I was trying to put a response in the chat box, but I wanted to address that the mandatory, the being late. I think that if you look at the automatic exclusion rule, and I think that's what people need to look at, I don't think that it is a, if you don't do it within 30 days, you're absolutely barred forever and ever from putting on that evidence. I think that if you fail to timely supplement under the automatic exclusion rule, that's what keeps you out. So if you get to a point in time where you're within 30 days of trial, because a timely supplementation is at least 30 days prior to trial. If you're within the 30 days of trial and all of a sudden somebody comes in with their initial disclosures when they have the oh crap moment, then it's discretionary with the court. And you had asked the question about the expedited action. I have handled a number of those, and again, they're in connection and they go hand in hand with the automatic exclusion rule. The automatic exclusion rule is especially effective against collections and banks because, and again, the expedited actions too, because those things are on the rocket docket because generally they were less than $100,000. Now, did it get us to trial quicker? No, absolutely not. And that was the basis of the expedited situation, because the object was to get you to trial quicker and streamline this process. But again, I think that under the automatic exclusion rule, it's a failure to supplement, timely supplement is what keeps the evidence out. So I don't think that it is a bright line test if you don't just make these initial disclosures within 30 days that you're forever and ever barred from putting on that evidence. So that's my opinion on that.
Yeah, and you are probably right. In the real world,
very good.
Yeah, in the real world, you're probably right. But I don't want to be the lawyer that gets caught with my pants down, so to speak, by not having disclosed them on time. So just, yeah, beware. Okay, anybody else? We've got some good things to think about, and I know you all have some kind of experiences or questions or can imagine something could go wrong. All right, well, I'm gonna go back to this and put up the course number one more time. Oops, it's not showing up. All right, hang on. Well, okay, we can share that one for sure. How about, there we go. There's our course information and our QR code if you need that. I suppose that, oh well, there we go. I suppose that we are kind of done here unless anybody else has any questions or wants to visit with each other. Yeah. All right, well, again, I want to thank you all for being here, for sharing your stories, for allowing me to organize this stuff so that I can learn better. And hopefully we can all learn together as we go through this process together. If you would like a copy of the PowerPoint, then I'm going to put my email address in here. I've got a copy of the PowerPoint I could send you. I've also got the video recording that I made of this, if anybody wants it. Because that PowerPoint that I stole from Corpus Christi, that is, yeah, it's just a good summary of what you need to think about as you navigate these new rules. So thank you again. Thank you to the Fort Bend County Bar Association for allowing us to start back with our monthly CLEs. I think that is the intention, that we will continue a monthly CLE either virtually or in person or both going forward. So keep looking for emails from the Bar Association. Look at the Fort Bend County Bar Association Facebook page. Yeah, sure. I will give you the course number one more time. Here we go. There it is. But yeah, so just keep in touch with your Fort Bend County Bar Association. We are trying to come back on to online, but not literally online, come back into some in-person events as well. And thank you to our board members who were on this call, which are Alicia Klosowski and Sharon Steckler, Tariq Gladney, our president, who helped to really organize all the registration and all for all of this. So thanks to all of them. And y'all are excused. I'm not going to close the meeting so that people can keep looking at that that course number, but y'all can leave if you want. You've done your time. You've got your course number. Have a great day.
Thanks, Margie.
Thank you. Thanks, Betsy. You were great.
Thanks.